All right, welcome debtors and borrowers to Bankruptcy Bailout, because debt ruins lives, not bankruptcy. My name is Matt Burkus. I'm a Colorado bankruptcy and student loan relief attorney, and today we're talking about the big news of the Navient private student loan forgiveness as a result of a settlement reached with 38 attorney generals across the United States. So let's get into it. We're going off of the actual text of the settlement agreement, and we're going to break down in a general way who qualifies and who doesn't to get forgiveness of their private student loans from Navient. So the first issue, of course, is you have to be within one of the 38 states. You have to reside within one of the 38 states that's participating in this settlement. Some of the states that aren't participating include Texas, Oklahoma, Utah, Montana, and a slew of others, obviously. I'll post a list in the comment section of this video, but there are states that are not participating. Now, the trigger for your residency is going to be your last known address with Navient. So that may catch a few people off guard. So if for example, if Navient thinks if your last known address was in Texas and you've subsequently moved to Colorado and never updated your address with Navient because you were ignoring your loans, you may not qualify. All right, so be careful. All right, but that's going to be an issue that's probably going to have to be sorted out. That's something you'll want to contact your attorney general about and see if we can get that clarified. I guess quickly backtrack, a point here about this settlement is the settlement has not been approved by the court just yet. So these are the proposed terms. Everyone's signed off on it, but the judge in the case still has to approve it. So there could still be some tweaks and changes to the settlement terms and to the debt relief terms subsequent to the posting of this video. All right, so first you have to be in one of the 38 states that's participating. Second, your loans have to be in charge-off status as of June 30th, 2021. So unfortunately, if you've been paying on your student loans, if you've been a good borrower and your loans are not past due in charge-off status, you don't get any relief. So there you go. Charge-off status means you haven't been making payments for 8 months, and that's when they get triggered for charge-off. So anyway, so the triggering date is any loans that are in charge-off status, or one of the requirements is any loans are in charge-off status as of June 30th, 2021, just about 8 months ago. The loans had to have been originated after 2002. Okay, so that's the window. So we're talking loans originated basically by Sallie Mae, the precursor to Navient, after 2002. So if you have private student loans, which weren't really that common way back then, but if you have some private student loans that predate 2002, that came from Sallie Mae, you're not getting any relief. All right. So here's what's, I think, causing a lot of confusion, and it is kind of unclear. But in order for your loans to qualify, they have to have reached, I'll just read the text real quick. So in order to qualify for categories 1 and 3 below, private education loans must be charged off as of the debt relief forgiveness date, that's the June 30th date, and have reached past due status no more than 7 years prior to the Debt Relief Forgiveness Act, or be within the applicable statute of limitations based on the borrower's last known address as of the date Debt Relief Forgiveness Act. So what that's saying is that it's not just that you have loans that were originally after 2002, and as long as they were charged off at some point, you get relief before June 30th, 2021. No, they had to go into past due status within 7 years prior to June 30th, 2021. All right, so do the math. What's 7 years ago from 2021? Well, that's 2014. All right, so your loans had to have been charged off after 2017, or if your state has a longer statute of limitations to sue, and there's only a handful of states that do, like Ohio is one of them. I think it's only three of the 38 states have a longer statute of limitations than 7 years to sue on a private student loan. Then you get that window. They can be charged off in that window. So if the statute of limitation was 10 years, you get 10 years and not 7. Where I practice in Colorado, the statute of limitations to sue on a debt is 6 years, So you get the benefit, or Colorado borrowers will have to have had their debt charged off within the 7-year window laid out in the agreement. So if your debts, and this is kind of a kick in the teeth a little bit, but if your debts have been charged off or in default past due status for a really long time, more than 7 years as of June 30th, 2021, you're not going to get any relief. Now, you may be beyond the statute of limitations for them to sue you, so it may be a non-issue in the grand scheme of things, and there's going to be some other relief for you as far as the debts coming off your credit report and so forth, but you're not going to get express forgiveness of your student loans under this settlement agreement. Okay, so that's the, excuse me, so that's the main requirement, and then there's 3 categories of, there are 3 other conditions for forgiveness. And the first is that basically this is relates to 2002 one, and it relates to specific programs from Sallie Mae. So the private student loans had to have been originated under what they call the Opportunity or Recourse Program and dispersed after 2002. So this relates to certain specific loan programs. Now, Category 3, we'll come back to Category 2 because that's the list of schools. Category 3 is for any non-traditional private student education loan, and this is a weird one, or this is an odd one, because it relates to your FICO score at the time you took out the loan. So if the borrower had let's see, what's this? Oh, here it is. So if a borrower with a FICO score below 670 at the time the loan was originated and attended a for-profit school, or relief is given to a borrower with a FICO score below 640 for a loan for a public or private not-for-profit school. All right, and that's your FICO score at the time the loans were taken. Okay, so this is addressing sort of the predatory aspect of private student loans, because private student loans do have a credit worthiness to them. They're not guaranteed by the government. They don't fall under the federal government lending guidelines, so FICO score is considered. So what they're saying is if you had really bad credit when you took out the private student loans, you're going to get some relief, and the FICO score. And the FICO scores are 670 for nonprofit schools and below 640 for public schools. Now, as far as what schools qualify, so again, you have the dates, which we talked about, 2002 to 2021, but effectively 7 years before 2021, your loans had to go into past due status or charge-off status. There's a list of schools. I'll go over some of the big ones here, but Apollo Group, Bridgepoint Education, Career Education Corporation, here's a big one, DeVry, the Corinthian College, they all folded back in 2010. ITT, that's a big one. Education Management Corporation, that's the art institutes, because I have a lot of clients that went to art institutes and have 6-figure student loans. So if you went to one of these schools, so here's some of the Lincoln Tech, Premier Education Group, Graham Holdings. I mean, these are the parent corporations to a lot of schools, so we would just have to do some research to figure out what your specific school falls under one of the schools in this group. But certainly art institutes, DeVry, ITT, a lot of career-oriented or technical schools that were for-profit schools. So if you attended one of these schools and your loans were in past due status within 7 years of June 30th, 2021, you're going to qualify for forgiveness. There's not, as it stands right now, looking at how they're going to implement this forgiveness, there isn't a whole lot you're going to do. The only issue is going to be is whether Navient has your last known address. So if you haven't communicated with Navient and you've moved around, you may want to get back in touch with them and let them know where you are if you're going to qualify for this settlement, because the settlement agreement, excuse me, the settlement agreement requires Navient to sort of be proactive and go out and reach out and find who qualifies for these loans. Now, on most of the settlement agreement, interestingly, most of the text relates to federal loan, Navient's federal loan servicing, but that's almost not applicable anymore because Navient is getting out of servicing federal student loans. But the one thing you might see is if you have federal student loans that were serviced by Navient, you may get a check for $260 if your loans were put in forbearance instead of an income-driven repayment program. Because one of the big problems with federal student loans over the last decade is that the servicers, whenever someone called in and is in financial problem or not able to make their payments, by default they would just put you in forbearance and they wouldn't discuss with you whether you should do an income-based repayment or some sort of income-driven repayment. And I've been saying for years, forbearance is the worst thing you can do because you're not making payments, interest is accruing, and then you get stuck, especially, and they'll just keep giving you these discretionary forbearances for 6 months. And I've seen people who've had discretionary forbearances for years, 3, 4, 5, 6 years, and suddenly their balance is almost double what it was when they went in forbearance. Where they should have done is gone into some sort of income-driven repayment program. So the settlement sort of addresses that issue, but a lot of the behind-the-scenes stuff of the settlement is directing Navient to be more proactive in communicating with borrowers, but it doesn't matter anymore because Navient's getting out of the business of servicing federal student loans. My name is Matt Burkus, Colorado bankruptcy and student loan attorney. If you need any assistance with any of this, certainly call my office, schedule a consultation. I do charge for consultations. It's a $169 consultation fee to discuss your student loan issue with you and figure out what your best options are. The nice thing about most consultations I do is I can usually get you pointed in the right direction, and you don't actually need to hire my services to do anything. However, we do specialize in negotiating settlements of private student loans, helping borrowers get public service loan forgiveness, getting on income-driven repayment programs for federal student loans, and also bankruptcy related issues with student loans. Remember, debt ruins lives, not bankruptcy. My name is Matt Burkus. Have a great afternoon.